In Nebraska, a woman has been charged with helping her teenage daughter end her pregnancy at 27 weeks after investigators obtained Facebook messages in which the two discussed using medication to induce an abortion and discussed plans to burn and bury the fetus. Now, in early June, Celeste Burgess and her then 17-year-old daughter, Jessica, were charged with a single felony, abandoning a body, and 2 misdemeanors, concealing the death of another and false reporting. Now, Jessica is being tried as an adult. But it wasn't until about a month later, after investigators subpoenaed, reviewed private Facebook messages, that they added felony abortion-related charges against the mother. Now, both have pleaded not guilty to all the charges. Prosecutors allege the pair had help from a 22-year-old man, Tanner Barnhill. Barnhill is cooperating with police and has pleaded no contest to helping bury the fetus in rural Nebraska. He's set to be sentenced later this month. Now, our affiliate, KMTV, has a look at recent court documents.
According to the document, Celeste told police she tried to call her mother to wake her up when it happened. She eventually went downstairs to tell her. Celeste then placed the fetus in a bag and then into a box in the back of a cargo van. The affidavit says the mother and daughter drove the fetus to a property north of Norfolk and buried it, but it does not say when this happened. They allegedly got help from 22-year-old Tanner Barnhill. This property belonged to his parents in Madison County. On April 29th, Jessica and Celeste showed a Norfolk detective where they buried the fetus. Tanner also arrived on scene and confirmed the location. He also told officers that Celeste and Jessica attempted to burn the fetus before burying it. That same day, Madison County Sheriff's officers helped at the scene, and the document says the fetus appeared to have thermal injuries. The investigation continued. During those weeks of investigation, the detective discovered Facebook messages between the two about abortion pills on April 20th, just 2 days before the stillbirth occurred. According to court documents, messages between Celeste and Jessica discussed how to use the abortion pills, and Celeste stated she couldn't wait to get the thing out of her body.
Now, quick note, the charges in this case are not directly related to the High Court's recent overturning of Roe v. Wade. The mother and daughter's alleged actions took place months before the ruling, but violated a long-standing state statute banning abortions after 20 weeks. The prosecutor said handling this case is really the first time he's had to charge anyone under that statute. Now, the case raises serious questions about government authorities monitoring social media in order to prosecute cases of illegal abortions. All right, still with me, trial attorney Erica Wilson, criminal defense attorney Franz Borghardt as well. Franz, I'll start with you. Do you have any issues as a defense attorney? And this is a big issue in the privacy community, in this battleground that is abortion, of course. For the state and authorities, the government, using subpoenas to big companies like Facebook and Google to find out your communications on those platforms in order to then use that against you in prosecutions, and in this case, specifically abortion.
Well, it's certainly a part of the government's subpoenaing power and their search warrant power. So in that sense, no, I don't like it, but it's something they can do. It certainly makes me uncomfortable, especially when we're talking about the conversations between a mother and a daughter about something as sensitive as pregnancy.
You know, what's interesting, Erica, I agree 100% with Franz, and the question becomes, how should the Googles and the Facebooks of the world handle these types of subpoenas? Now, in this case, they didn't mention abortion at all. They were looking for what they thought at the time was a burnt body, is what they called it in the actual subpoena. And so they didn't know. But how do you think they should respond in the future to these types of inquiries if it involves abortion?
Google and Facebook and all of these major social media conglomerates, they have a powerhouse of attorneys who are built to deal with these type of things because it comes up all the time. Attorney Franz can tell you, most criminal cases, there's some level of social media aspect in there, and so we just have to kind of deal with it and address it as it comes up. But they will handle it accordingly based on the laws. Unfortunately, our hands are tied as criminal defense attorneys. They're allowed to get the information.
Yeah, and Franz, what's interesting, and the problem is, you look at this from a slippery slope standpoint. A lot of the various advocacy groups are talking about the fact that, if you're corresponding with a friend about maybe going to another state or perhaps getting this stuff through the mail, which you're not allowed to do in a number of states, those are the types of things that they're worried about, that people could find themselves under the gun for those types of things. And again, I don't want to say it shocks the conscience, but it certainly raises some issues.
So what we're talking about is a constitutional right to an expectation of privacy. And it's a slippery slope, right, Michael? The more there's kind of erosion on this, the more we're like, well, do we really have a right to privacy? And what we're seeing when we're talking about social media, when we're talking about the expansion of that is, well, no, at the end of the day, if you're communicating with someone, if you're not whispering in their ear in a small, quiet tone, you really don't have a right to privacy.
Yeah, and that's it. If you want to be private, don't go on social media. All right. Well, thanks to Erica Wilson and Franz Borghout for joining me tonight. Truly appreciate you guys. We'll see you again soon.